Welcome to Before the Appeal, a California litigator's pre-appeal checklist. I am Brianna Rucker, Diversity and Inclusion Committee Chair of BHBA's Barrister Section, and I'm super excited to introduce our speakers today, Laura Lim and Kent Toland. Kent Toland is an associate with Greines, Martin, Stein, and Richland LLP. He has handled appeals before the California appellate courts involving commercial real estate, anti-SLAPP law, property rights, secured transactions, contracts, and writs of attachment, among other subjects. Before joining GMSR, Kent was a litigator at a mid-sized California law firm that in the trenches experience gave him a robust understanding of all phases of litigation and makes him well suited to advise clients and trial counsel on preserving issues for appeal. Laura Lim is an associate with Greines, Martin, Stein, and Richland LLP, and before joining GMSR, Laura was a research attorney for Justice John S. Wiley Jr. at the California Court of Appeal and a law clerk for Judge George H. Wu in the Central District of California. In her work at both the appellate and trial court levels, Laura drafted opinions and orders spanning a wide range of complex civil issues. Laura also worked at an international law firm as a litigator with an emphasis on data privacy. She helped clients interpret evolving privacy regulations and navigate data breach notification requirements. And without further ado, let's get started.
Thank you so much for joining us, everyone. We're so excited to share a little bit about California appeals with you. The purpose of this presentation is to provide an overview of some essential pre-appeal considerations that will help you determine whether you can appeal and help you evaluate the strength of an appeal, all before you even file anything with the appellate court. We will cover 5 basic tips, which fall under 3 categories. The first category is, can you appeal? Within that, we'll go over what exactly is appealable and what's the deadline by which you need to appeal. The second category is assessing whether you should appeal. Within that, we'll cover standards of review and the requirement that the appellant must show prejudice. And finally, we'll go over what it means to have a complete record on appeal and why that's so important. For each tip, we primarily will focus on the appellant's perspective, but we'll also consider the flip side, the respondent's perspective, the perspective of the person who prevailed in the trial court, and we'll go over how that side can assess these same issues. Please feel free to put questions in the Q&A box below. We will try to cover them as we go along, and we're happy to answer them at the end if you have some then too. So with that, I will pass it over to Kent to kick us off with letting us know what exactly is appealable.
All right, thanks, Laura. And yeah, thank you everyone for being here today. We're really happy to share these tips with you. And as you can see from that previous slide, each tip is really framed as a question. Questions that you can ask yourself as you're thinking about whether you want to take an appeal, or whether you can, whether you should. So we hope that these 5 questions just help you to see strategic opportunities and things to be thinking about in that process. So the first one is it appealable? So whatever you're trying to appeal from, a judgment, an order, can you actually appeal from it? And so we're going to go over the rule, the general default rule, and then the exceptions. And there are plenty of exceptions to this rule. So the default rule is the one final judgment rule. And so what that means is that there's one final judgment in an action, and that's what you can take an appeal from. So if the case goes to trial, the jury returns its verdict, and then judgment is entered, the default rule is that's what you would take your appeal from. And so a couple things to note on this is that it's a statutory right. It's created by statute, and CCP section 904.1 subdivision A1 is what codifies the one final judgment rule. But there are plenty of exceptions, and so that's what we're going to look at next. So you want to ask yourself, if it's not the one final judgment, is there an exception that would apply that would make this appealable? Some of those come from CCP, section 904.1 as well. There's several subdivisions that list out different exceptions. And we're going to touch on just a few of those to illustrate how this works. So the first exception we have here is an order granting a new trial. So the verdict has been returned and the judge hears a motion for new trial and grants that motion, that's immediately appealable. And so that means, that instead of having to do a new trial again, go through all of that all over, first the party who won at trial and then had that verdict set aside in favor of a new trial could appeal right then. There's also order denying JNOV. That's immediately appealable as well. So these first two examples are post-trial motions that would be ruled on and judgment hasn't been entered yet, but they're appealable. There's also some provisional remedies that are appealable under the statute. We have injunctive relief. So this could be an order granting or denying a preliminary injunction, for example. And so if you have filed a motion for preliminary injunction and it's denied, you could take an appeal from that. And that's really helpful to know because this could be at the very beginning of a case, just after the complaint's been filed. It could be in the middle of discovery. Trial is a long way away. And so this is an opportunity to appeal early on if you think that an injunction has been entered against your client that shouldn't have been, or that the court erred by denying your client's request for a preliminary injunction. Later, we'll talk about the standards for how courts assess these kinds of appeals, but right now we're just focusing on what is appealable. And one thing that I want to touch on, we won't go into detail as much with this today, but it's also important to be thinking about when you can't appeal, what happens to the order or the judgment you're appealing from. And what I mean by that is, will enforcement be stayed, or is it still enforceable even as you're appealing? The answer is it depends. And, that's a common answer to a lot of our questions as lawyers. And what it depends on for an injunctive relief, for example, is whether the injunction is mandatory or prohibitory. So if you have a mandatory injunction compelling your client to take affirmative action and you appeal from that, not only is it immediately appealable, but the enforcement of the order is stayed during the appeal. But that's not the case for a prohibitory injunction, which restricts your client from taking action and prohibits them from taking certain actions. That is immediately appealable, but enforcement is not automatically stayed by appeal. So again, we're not going to go into all the details of stays, but I just wanted to note that that's something to be thinking about as well as you're thinking about whether something's appealable. What's the consequence of filing a notice of appeal as for the enforceability of what you're appealing from? And then we have another exception listed here. If you have an order appointing a receiver, so another provisional remedy here, that's immediately appealable. For those of you who have litigated in cases that involve receivers, this can be a significant remedy. Maybe a business is really taking a turn for the worse, like things are going south, and one of the parties claims that a receiver is needed to right the ship, basically, to come in and take control. If that application is granted, the party that opposed that application can file an appeal immediately. And that makes sense too. If you have a receiver appointed who would take control of books and records, start making all sorts of decisions to essentially take control of the business, you can't really unscramble the egg once that has happened at the end of the litigation. So that shows why that would be an exception to the one final judgment rule as well. So those are a few exceptions under the statute, and there are more. There are more under CCP section 904.1. There's an order from an anti-SLAPP motion that's immediately appealable as well. And then there's other sources of law, for example, the California Arbitration Act. If you have an order denying a petition to compel arbitration, that's another one that's immediately appealable. And there, otherwise the parties would have to litigate at trial, and there would be no chance to really seek meaningful appellate relief to go to arbitration, because then you can't avoid trial if you've already done it. So that helps that it's immediately appealable. If you believe that decision was erroneous, you can file an appeal from that as well. Those are some examples. We've also included an appendix at the end of the slides, and it highlights other examples of other sources of law or doctrines that make certain other orders appealable. So hopefully this has shown that yes, there's a one final judgment rule. That's the default rule. There are many exceptions, and it really pays to know these exceptions. We haven't given an exhaustive list, but if you know these, and especially the ones that come up more often, it's really helpful for you in serving your client to recognize that, oh, okay, we can take an appeal from this now. We don't have to wait this preliminary injunction has been entered and we think it's wrong and we think it's really harming our client, you could appeal from that now. And otherwise, there might be no meaningful relief at the end of the case, or you might have to wait years to get any sort of relief from, say, an erroneous injunction. And as a respondent, from that perspective, if the other side appeals, you want to be thinking about, is that actually appealable? Can they do that? And if the answer is no, if you don't see any grounds, you've checked all the sources, including CCP section 904.1, and you don't see any grounds for it to be appealable, that could be a good opportunity for a motion to dismiss, to show that the appellant is asking to appeal from something where the court does not have jurisdiction. It's a jurisdictional bar. If it's not appealable, then it shouldn't be before the Court of Appeal, and that could help you to avoid the time and cost and delay of briefing on appeal. And one last thing I'll note before I hand it over to Laura for our next tip is that another reason to know what kinds of orders are appealable is that appeals are use it or lose it. So if one of these orders happens and your client's aggrieved by it, you believe it's erroneous, it's important to recognize it when it happens so that you can protect your client's rights. And with that, I'll turn it over to Laura for our next tip.
Thanks, Kent. So our next topic we'll cover is when is the deadline to appeal? And by deadline to appeal, we mean the date by which you need to file the notice of appeal with the Superior Court. This is what kicks off the entire appellate process. The deadline here is jurisdictional. This means that timely filing a notice of appeal vests jurisdiction with the Court of Appeal and generally terminates the trial court's jurisdiction. This is the one appellate deadline you cannot miss. As some of you may know, in the appellate world, deadlines generally can be flexible. Opposing parties will routinely stipulate to extend briefing deadlines. Even the court deadlines for some briefs have a grace period within which you can file your brief, an opening brief or a respondent's brief, and still have it be considered timely filed, even if you missed the actual deadline to file the brief, as long as you filed it at some point within that grace period. That is not the case here. This is the one appellate deadline for which there is no grace period. Parties cannot stipulate to extend or shorten, for that matter, the deadline for filing a notice of appeal. And courts have no authority to excuse a tardy filing. There's no relief under CCP 473 for mistake, accident, inadvertence. There isn't anything of that sort. So missing this deadline is in fact fatal to the appeal. And so our main practice tip here is definitely heed the deadline and calendar it immediately and file sooner than later. What is the deadline? Rule 8.104 generally governs it. The typical deadline is 60 days after service of notice of entry of judgment or notice of entry of order. So either the Superior Court clerk or a party can serve notice of entry. And if nobody serves such notice, then the deadline is 180 days after entry of judgment or entry of order. Again, this is a strict deadline. Even if the clerk re-enters the same order, or if a party, for some reason transmits a second notice of entry, that doesn't restart the appellate clock. But under Rule 8.108, the deadline can be extended if the trial court denies certain post-trial motions. The rule lists out all of the different types of post-trial motions and the corresponding extended deadlines. I won't go through all of them, but for example, say you file a motion for new trial and the court denies that motion. Your deadline to appeal is now the earliest of 30 days after service of the order denying your motion for new trial, or notice of entry of that order, or 180 days after entry of judgment, whichever is sooner. The same deadlines will apply for a motion for JNOV if you file one and it gets denied. I should note, though, that these extensions only apply if your post-trial motions, A, are valid, and B, are timely filed. Otherwise, the deadlines will remain the same, as if you didn't file any post-trial motions. So on the other hand, if you are the respondent, so if you prevailed in the Superior Court, you should still be mindful of the deadline to appeal, because when the other side files a notice of appeal, you should check to see whether that appeal is indeed timely. And if not, as Kent was kind of saying, for orders that indeed are not appealable, you should move for dismissal. And if it makes sense, request a stay of the briefing deadlines until this timeliness issue is resolved. The reason for this is whether or not an appeal is timely isn't always readily available or readily accessible to the Superior Court clerk, especially if the appellant misses the deadline by, say, a day or two. It's not always immediately obvious. And sometimes the Court of Appeal might not independently realize this error either, and they'll docket the case. And in some instances, no one will realize until all the briefing has been submitted and a Court of Appeal research attorney is combing through the record and notices, like, oh, this wasn't even a timely appeal. So it's definitely worth raising the issue before you unnecessarily spend all your time and your client's resources on reviewing the entire record, drafting a brief. This actually recently happened in a case that I was working on. We represented the respondent, and we knew that the other side was going to appeal, and they filed a notice of appeal 1 day late. The Superior Court clerk didn't notice, and the Court of Appeal didn't notice at first either. And so the appeal got docketed, and we drafted a motion to dismiss. We were prepared to file it, and in the interim, what happened was the Court of Appeal clerk caught on and issued a letter to the parties asking appellant to explain why the appeal shouldn't be dismissed because it's untimely. Long story short, appellant missed that deadline as well, and the case got dismissed. But we were prepared to file a motion to dismiss if needed. In any event, the main takeaway here is you don't want to miss this deadline. When in doubt, definitely file early to ensure that you preserve your client's rights. And we also advise not waiting until the very last day to file, just to avoid any last minute issues, a glitch in the filing system. Some superior courts have like an appellate division where you need to go file in person, and if there's an issue with the attorney service you're using, it's best to leave yourself sufficient buffer time. Yeah, and so with that, I will pass it back to Kent, and we'll talk about what happens once we get into the merits of the appeal.
Great, thank you, Laura. Yeah, so we've covered the first two questions in the category of can you appeal. So now we're assuming that this is an appeal that can be taken. The order is appealable, or it's from the final judgment. Notice of appeal was filed timely, and now we're in the world of the merits, or if you're still evaluating whether to appeal, should you appeal? And so that's what this tip and the next one go toward. And this tip here, number 3, what is the standard of review? This question to ask yourself, this is really probably the heart of our presentation, because once we get into the merits of the appeal, this is a question in every appeal we think about a lot. It's really important. It can be determinative. If not determinative, it can still be very influential in how we view the appeal as the attorneys, and certainly how the Court of Appeal will view it as well. So before we talk about the different standards of review, what is that? What does standard of review mean? Well, it's the threshold issue in every appeal, and what it means is it's the lens through which the Court of Appeal is going to view the case. It's the amount of deference, the measure of deference that they're going to show to the jury verdict, or the trial court statement of decision, or an order that the trial court entered. And there's a spectrum here. So the Court of Appeal does not automatically give a fresh look to any appeal that comes before it. Sometimes the court will show quite a bit of deference to the trial court. Other times, no deference. And it depends on the nature of the case, on the nature of the issue that the appeal focuses on, or the issues, plural. So the standard of review is really important for assessing in advance, should you take this appeal? It's important to help you and your client count the cost, to evaluate your chance of succeeding on appeal. This is an essential step to figure out what your chances of success are. And I hope that as we go through these standards, you'll see the differences and you'll see why this matters so much. So at the outset, then, once you know the standard of review, you can ask yourself, okay, what if this is a difficult standard of review? If the court's going to defer a lot to what happened at the trial court, to what the jury found, what's our best argument under that standard of review? What's our best shot to say, yes, there's a lot of deference here, but this is the appeal that should succeed. This is the appeal that should overcome that deferential standard. Those are the kinds of questions that are really good to ask at the outset before you take an appeal. An appeal can take well over a year to brief from beginning to end. The briefs can be very extensive. It can be very costly. And so it's about counting the cost and making a reasoned, thoughtful decision with your client of whether or not you think this appeal is worth pursuing, and then figuring out your arguments as part of that. Okay, so as we look at each standard of review, there's one more thing I want to point out before we get into each one. And what we want to do is keep in mind that appellate courts generally do not resolve factual issues, factual disputes, or evidentiary issues. They're really more focused on questions of law as a general rule of thumb. So that basic rule of thumb underlies these standards of review and how much deference they're going to show to a given order or judgment. So with that, there's 4 standards of review here, and Laura and I are going to go through each of them and take turns here. So I'm going to start with the first one, and it's the substantial evidence standard of review. So what this means is if the Court of Appeal is looking at an appeal that is under the substantial evidence standard of review, that means it's looking for whether there is sufficient evidence to support the order or judgment. And I've got a couple case law quotes to help illustrate what this means and how it works. So in Schmidt versus Superior Court in 2020, the court described it as when a civil appeal challenges findings of fact, the appellate court's power begins and ends with the determination of whether there is any substantial evidence, contradicted or uncontradicted, to support the trial court's findings. And there's a common misconception about this standard. Oftentimes, fairly often, appellants will want to come to the Court of Appeal and re-argue the evidence. They may want to claim this witness testified X, but it just was not credible. Or, they testified X, but our side testified Y, and that was more believable. The jury really should have believed our side. That was clearly the truth. The other side was not telling the truth. Or argue some sort of other factual issue. Well, if you've gone to trial and the jury has rendered its verdict, it's likely going to be a substantial evidence issue. If it's a factual finding that you're challenging, then that's going to be substantial evidence. And so the misconception here is that the appellate courts, they're not going to resolve conflicts in evidence. And here's another quote from case law. We do not review the evidence to see if there is substantial evidence to support the losing party's version of events, but only to see if substantial evidence exists to support the verdict in favor of the prevailing party. And so just to give kind of a hypothetical example, let's say you go to trial on a breach of contract claim and the plaintiff prevails, the jury returns a verdict in favor of the plaintiff, and let's say you're representing the defendant and you want to appeal from that verdict. Under the substantial evidence standard, questions would be, for each claim, for each element of the claim, was there a contract? Was it breached? Were there damages, for example, as some of the elements? Those would be viewed for substantial evidence. It would not be, the Court of Appeal would not look to resolve any he said, she said disputes over whether or not they had, say, a handshake deal. They would not really be looking at the credibility of the evidence. That's really for the trier of fact. In a bench trial, the judge, and a jury trial, the jury. And so that's their province. That doesn't mean that a substantial evidence appeal is impossible. They can succeed, but it's more rare to succeed under the standard of review. It's an uphill battle for sure. And if it doesn't mean that any evidence whatsoever would satisfy the standard, it has to be substantial. And there's case law that describes what that means. But basically, there needs to be enough evidence to pass muster, that it wasn't just totally unreasonable for the jury to find in favor of the prevailing party. And so it could be a small bit of evidence, though. It could be one witness's testimony. That testimony could be contradicted. That could qualify as substantial evidence and be enough for the Court of Appeal to affirm. So the takeaway is that this is a difficult hill to climb. And it's important to be aware that you're not re-arguing the evidence in this kind of appeal. That's a mistake that we see. Appellants that might chase an appeal that really has a low standard or a low probability of success. And then they might fail to tailor their argument to the standard of review. If they're arguing factual questions under the substantial evidence standard, that's probably not going to succeed. And so avoiding that and being able to advise your client thoughtfully as to why or why not it's in their best interest to pursue an appeal really benefits them. And so that's why we want to highlight these standards. Again, it's not impossible to prevail, but it's important to know what you're looking at and what you're trying to tackle under this standard. It's not just a blank slate for the Court of Appeal. There will be quite a bit of deference. So I'll pass it to Laura for our next standard.
Thanks, Ken. I see that we do have two questions. Really quickly, we have a question about the case citation for substantial evidence standard of review. At the end of our slides, which I think will be circulated or have been circulated, there is an appendix, and we have case citations for all 4 standards of review that we will cover today. And so we will circulate those, and if you would like more citations, please feel free to email us. We're happy to send those along. And then there was another question about appealability. There is a case in which the court refuses to issue a final judgment, and a notice of appeal was filed. The question is, can I ask the court to rule on appealability by motion? Without knowing more about the case, it's hard to give a direct answer here. The short answer is probably not. But I think what we would advise is maybe knowing that your client doesn't want to spend their resources litigating a full appeal, maybe consult with an appellate lawyer for perhaps 30 minutes or an hour just to get a sense of whether whatever you have appealed is appealable. Yeah, Ken, do you have any follow-up to that?
Sure. Yeah, I don't think we can answer like specific case questions during this program. But if that's something that you want to reach out to an appellate attorney about, certainly that could be a good idea to do so. We just can't really go to a specific question there, but hopefully the content that we're giving helps point you in the right direction of things to consider in that case. So yeah, Laura, do you want to go ahead?
Yeah, sure. So our next standard of review we'll cover is the abuse of discretion standard of review, which, as the name implies, applies to the review of discretionary trial court rulings. Discretion doesn't mean that the trial court judge can do whatever they want. It's been described as the sound judgment of the court to be exercised according to the rules of law. So there still are legal parameters, but they're quite broad within those parameters. Under this standard, the reviewing court will disturb a trial court ruling only upon a showing of a clear case of abuse. Discretion is abused only when the trial court exceeds all bounds of reason. Rulings that constitute an abuse of discretion have been described as ones that are so irrational or so arbitrary that no reasonable person could agree with it. This, similar to the substantial evidence standard of review, is an exceedingly deferential standard. In deciding whether a ruling constituted an abuse of discretion, the reviewing court will view the entire record in the light most favorable to the court's ruling. So if there are multiple inferences that can be made from the evidence, from the testimony, the reviewing court has no authority to substitute its own decision of what these inferences are for the trial court's decision. Some examples of these discretionary rulings include granting or denying an injunction, an evidence code section 352 ruling on admitting or excluding evidence based on prejudice or how probative it is, the amount of attorney fee awards, and discovery rulings, for instance, motions to compel, protective orders, sanctions. And it makes sense that appellate courts will defer to trial courts in their discretion for these types of very fact-intensive rulings. When I worked as a Court of Appeal research attorney, we talked about this all the time in chambers. For us, reading the cold record, reading a hearing transcript or a trial transcript on our screens, or sometimes we would have the paper copies, it's really no substitute for actually being there, being physically there to hear witness testimony, see the evidence firsthand, assess someone's body language, their credibility, hear their tone. Because we, as the Court of Appeal, were so far removed from the proceedings, the Court of Appeal justices really were loath to find an abuse of discretion where there was at least some justification for the ruling. So it's definitely a tough standard of review for the appellant. It's a heavy burden to show that the trial court had no reasonable basis for its action, or that no reasonable judge could have made this decision. Courts have described the standard as the appellant facing a daunting task, an uphill battle. One court has even described these cases generally as dead on arrival. But all hope is not lost. I have worked on cases here at this firm where we have prevailed under this standard. In one instance, we were representing the respondent and we were the appellant, and our client was appealing a cost of proof attorney fee award. The other side was arguing that our client unreasonably denied requests for admissions, and they were seeking to recoup the fees and costs they incurred in proving those issues at trial. In assessing this type of award, the trial court has to consider certain criteria, certain factors. Here, the trial court didn't do so. The court essentially made up a number. The rationale was that from the litigation's inception through trial, in the judge's experience, the level of lawyering by the other side's attorneys was of very high caliber. So just based on years and years of experience, the court decided that this amount was appropriate. So on appeal, we argued that this was an abuse of discretion. There was no reasonable basis for this number awarded. In fact, there was no basis for this amount. And the court's decision, while there is discretion, it wasn't within the legal parameters required for this type of decision. The Court of Appeal agreed, and we secured a reversal. So it's doable, but perhaps this example does illustrate the level of egregiousness that it takes for a reviewing court to say, okay, yes, this was an abuse of discretion, we will reverse. So yeah, we've covered two pretty deferential standards of review. I'm going to pass it back to Kent to discuss a more appellant-friendly standard.
Sure. So yeah, we've talked about how it's not always a fresh slate, not always a fresh look that the Court of Appeal is going to give, but this next standard, that's what the standard is. De novo, our third standard of review, that is a fresh look. The Court of Appeal is going to not show any deference to the trial court, and it's going to make its own ruling independent of what the trial court decided. And this goes back to our point earlier that kind of the dichotomy between questions of fact and questions of law. De novo is typically for legal questions, and the Court of Appeal, that's absolutely in the court's wheelhouse. Legal questions is a big part of what the appellate system is for, to make sure there's uniformity of law. So some examples of when de novo applies would be constitutional issues, statutory interpretation, interpretation of writings, that could be contracts, wills, and so on. Anti-SLAPP motions get de novo review as well. And on the contract issue, there is contractual interpretation is reviewed de novo. An exception would be if you have parole evidence, and specifically conflicting parole evidence, that is admissible to help interpret the writing. That's going to typically be a question for the fact finder. And so I've seen that in cases where it's a de novo review of the contractual interpretation. But if it turns on that parole evidence, that extrinsic evidence that's conflicting, and that becomes a factual question of what, say, the agreement is ambiguous and two sides thought it meant something different, that specific part of it won't be de novo. But in general, reviewing a contract will be de novo review. And so this is much more appellant friendly. As Laura was saying, this is a much better territory to be in because you're on more equal footing with the respondent. Not entirely, we'll get to in slide 4, there's still more that the appellant has to show, but it's a much better starting point generally than being a substantial evidence review or an abuse of discretion review. And so it can also include, I want to mention, appeals where you have the facts are undisputed. And so the question is a pure question of law. So the fact that there are some facts involved in this determination, if they're undisputed, though, we could still have a pure legal question that would get de novo review from the Court of Appeal. I want to pause. I see we have a couple of questions. These are, let's see, we have one. How do you stack in strict scrutiny versus other constitutional standards under federal versus state constitutional law? That's a great question. So that's, I'll speak to it briefly. We're not as focused on federal today, but if it's interpreting like the Constitution, say the California Constitution, whether something is constitutional, that would start as de novo, and then if there's further case law as to what kind of scrutiny is given, yes, that could affect the interpretation as well. So that is certainly something to consider as well in those constitutional issues. And then someone's asking, is it worth appealing discovery motions time-wise? What is the estimated time for resolving this type of appeal? Laura, I can take it or you can, either way.
Yeah, either way, yeah, I can take this one. The answer is, as with most things, it depends. It depends on the impact of this discovery motion, what's important to your client. We have some clients who like using appeals as settlement negotiation tactics, and so it really depends on like how important is this to your client in the long run and how it impacts the overall case. Time estimate for resolving these types of appeals, it also very much depends. When I was working in the Court of Appeal, I was in the second district here in Los Angeles, and every single division had a different time frame within which they would complete an appeal. Some divisions had a huge backlog and others were a lot more efficient. It really just depends on where you land division-wise and who the justices are. The complexity of the case often impacts it. If it's a really long record and it's a very fact-intensive appeal, it often will take the research attorney assigned to the case a long time to sift through all of it. And it also even depends on if the panel can agree. If there's some discussion about whether we should go one way or the other, then that also takes time. And on the other hand, if it's a very straightforward appeal, the facts are simple, and that's also hard to assess from the litigator side too. It just depends on like what the justices are interested in and the amount of time that they spend on these issues. So hopefully that's a little helpful, even though it's a little bit, it's not a direct answer, but it really just depends on the type of case.
Oh yeah, and pardon me, Laura, I was just going to add that generally, as Laura mentioned, those would fall under abuse of discretion. So, there's going to be a lot of deference shown. And a good way to think about it under abuse of discretion is this something where the trial court really could have gone either way? Or is it just so clearly wrong? And now, as a former trial lawyer, I know that I often feel like I'm clearly right. Another side is clearly wrong. It's good to take a step back and just think about, okay, if I had to pitch this to somebody else and show that there's just no other way to rule, that the trial court absolutely got it wrong, is that effective here, or is this really like they could have gone either way? Even though I don't like the ruling, you could think about that. You could even talk with a colleague or another attorney and just kind of from someone who isn't right in the middle of it. Sometimes that's helpful to to see. But I think that that's a key question to be thinking about. Is it really could have gone either way, or is it just something that's totally wrong? That'll be an important question to be able to think through. So the next one, and thank you for these questions. I see, are all summary judgment motions subject to de novo review? Does de novo allow for re-arguing the facts of the case? As to the first part of that question, Laura's actually going to get to that in a moment, so we'll set that aside for a minute. And do you re-argue the facts of the case? It's kind of hard to say out of context, but usually it's a legal issue, so there's not as much argument about the facts under de novo. Every case is a little bit different, but typically the focus, how the appeal will be teed up, is you could be arguing about what a contract means, and that's kind of factual, but it's ultimately a legal question about undisputed facts. You have words on the page. What do they mean? So it's not really as much about re-arguing facts. It's about showing that there was legal error, is what I would say. And then the last question, I don't know if we could really speak as much about like the reputation de novo review. But if you're curious about just appeals in different districts, the Judicial Council publishes a report annually that shows like how many appeals are being handled at a high level, kind of how appeals being granted versus not. So that doesn't get maybe into as much detail as this question, but there are some interesting statistics out there to see caseload, to see some trends that the Judicial Council shares. Laura, do you have anything you want to add on that one?
Not really. I mean, even from my time working there, I don't know that there was a general reputation regarding certain standards of review. At least where I worked, the justices really did try to adhere to those standards. Like if it was de novo review, like we really do take a fresh look at everything. And if it's a more deferential standard, like substantial evidence or abuse of discretion, the tendency is just to defer to the trial court, just given the nature of us being so far removed from the facts.
Sure. So I think I'm finished with de novo there. It's deferring to the trial court, or not deferring, taking a fresh look. So I'll pass it to Laura for our fourth and final standard on this slide.
So our final standard of review we'll cover is a standard of review where the evidence is taken in the light most favorable to the appellant. In certain narrow circumstances, the appellate court will view the evidence in this light, the one most favorable to the person the party that lost in the Superior Court, and will accept as true the allegations in the appellant's pleadings. For example, like if there was a demurrer sustained, the allegations in the complaint would be accepted as true. The standard obviously is very helpful for the appellant because when the standard of review presumes the truth of the evidence in your favor, you have far greater leeway on appeal. For example, in your statement of the facts in your opening brief, you're able to emphasize the evidence that's favorable to you. You aren't restricted by these substantial evidence restrictions that we've discussed earlier. Examples of orders or rulings to which this standard applies is, as I was saying earlier, when a demurrer is sustained, the Court of Appeal will assume the truth of all the facts properly pleaded by the appellant. Or if there is an instructional error, when you're claiming that the trial judge gave an erroneous jury instruction or erroneously refused a particular instruction, the reviewing court will view the evidence in the light most favorable to the claim of instructional error, meaning the court will assume that the jury might have believed the evidence upon which this instruction favorable to your side was based. Another example is a JNOV grant or a non-suit or a direct verdict. The appellate court will view the evidence in the light most favorable to the appellant, so the party that obtained the jury verdict, which got vacated, or the outcome ended up going the other way based on the JNOV grant. Similarly, for appeals from judgments after a non-suit or a directed verdict, the reviewing court will reverse if substantial evidence supports the appellant's case. So if substantial evidence supports your side. And this relates to the summary judgment question we had earlier. When summary judgment is granted and the party the party subject to that judgment appeals, the reviewing court will view the evidence in the light most favorable to the appellant, so the party against whom summary judgment was entered. And the reviewing court will resolve all doubts about the propriety of granting the motion in favor of the motion's denial. So it's a pretty favorable standard when the reviewing court is reviewing the facts and the evidence. It's a little bit tricky because the overall standard of review for a motion for granting of a motion for summary judgment, so the overall grant or denial of summary judgment, is subject to independent review on appeal. So whether the trial court got it right is something that the appellate court will independently review. But the underlying facts and the evidence are viewed through a lens that is favorable to the party that did not prevail. And I think that's all I had for this fourth standard of review. I will go ahead and pass it back to Kent for some perspective from the respondent's side.
Yeah, thanks, Laura. So as we have on here, these are basically arranged as being less to more favorable for the appellant in terms of these standards. So as you were able to gather 3 and 4 de novo, light most favorable to the appellant, that's better territory to be in as the appellant. And so kind of opposite would be true for the respondent. If you're defending a judgment or an order on appeal and it's de novo review or light most favorable to the appellant, that will be a tougher appeal to defend against potentially. And so the standard of review, both sides should be thinking about this before the appeal, at the outset of the appeal, throughout the appeal. It shapes almost everything. It really shapes how you present the case as a respondent. It shapes how you defend against it. And so just a couple points, part of this depends at a high level on whether or not the appellant really had their day in court. If an MSJ is granted, if a demur is sustained, they didn't really get their day in court. They didn't get a trial by jury. And so it's more favorable there. But if you go to trial and you get a verdict from a jury, absent, say, jury misconduct or instructional error, if you're challenging just the factual determination in the verdict, that won't be as beneficial to the appellant because they got their day in court. And so just a couple other points from the respondent, you really just want to consider, how does this shape the playing field? If it's a substantial evidence appeal, did the appellant fail to cite unfavorable evidence? Did they only cite the evidence that favors their side? There's plenty of case law where appellants misunderstand the standard of review. They want to argue their affirmative case again, and they're not acknowledging the evidence that could support and does support the factual determination below. That's a great thing to call out in a respondent's brief. We see this fairly often where where a party's not really acknowledging and tailoring their arguments to the standard of review. If it's abuse of discretion, do they argue why it's an abuse of discretion? Do they argue why it was irrational, arbitrary, how this ruling is one that just could not have been made by a reasonable person? Or are they just trying to re-argue it just as they were arguing it to the judge in the first instance? If they're just kind of re-arguing without acknowledging the discretion that the trial court has, that's another good thing to point out as the respondent, really to look at that discretion and appeal to the trial court's discretion that it has for that kind of ruling. And also, sometimes appellants don't discuss the standard of review at all. Certainly, you want to be discussing the standard of review in your appellant's brief, your respondent's brief, but sometimes parties don't do that. And that is definitely something that you would want to flag as well. It's essential to framing your case on either side. And for the respondent, really helpful to assess the strength of the appellant's position. Okay, so I'll pass it to Laura for our next one here.
Thanks, Kent. Our next topic is assessing whether there was prejudice. So on appeal, it's not enough just to show that there was some error that occurred. The Court of Appeal will reverse or modify a judgment or order only for prejudicial error as opposed to harmless error. In other words, you have to show that the error resulted in a miscarriage of justice, that the error impacted the case's outcome. It has to be reasonably probable that a result more favorable to you, the appellant, would have been reached without this error. What it really boils down to is, did this error matter? As one very simplified example, say, for example, you made a hearsay objection at trial. The trial court overrules that objection. If this is a personal injury case involving a car accident, if the witness said, I heard that plaintiff was intoxicated and got in the car and started driving, then you could quite plausibly argue that the ruling impacted the case's outcome, that allowing the jury to consider this evidence, this hearsay evidence, was prejudicial to your case. On the other hand, if the witness said, I heard that plaintiff was wearing a blue shirt, but in reality, plaintiff was wearing a green shirt. Assuming that what plaintiff was wearing wasn't relevant to the appeal, then you probably will have a tougher time arguing that allowing this hearsay testimony in impacted the case's outcome. And this is a type of error that, while it was erroneous to allow the testimony in, it may fall more on the harmless error side, and the Court of Appeal won't reverse or modify, the order or the judgment based on this error. In this context, a probability that the error would have, that the absence of the error would have affected the case's outcome doesn't mean, like, you don't have to prove that that it would have been more likely than not that you would have prevailed. You just need to demonstrate that there was a reasonable chance, more than an abstract possibility, that had this error not happened, the outcome would have been different. So the bar is not exceedingly high, but you do still need to make a complete prejudice argument. You can't just say, like, broadly, there was this error and we were prejudiced. You need to, in your opening brief, spell out exactly how this error caused a miscarriage of justice, based on the particulars of this case. Otherwise, the reviewing court will deem the error harmless and won't the outcome won't change. It's also worth noting that the Court of Appeal will review the entire record to determine whether or not an error was harmless or whether or not it was prejudicial. So as you're assessing whether to appeal and assessing the strength of your appeal, it's worth considering, in light of the entire record, in light of all of the evidence presented, all of the testimony presented, did this error matter? And even as the respondent, when you're drafting your respondent's brief, you really should consider two things regarding this prejudice requirement. One is, did the appellant make the prejudice argument? And two, did that argument have any merit? If the appellant didn't even argue prejudice, which does happen sometimes, then that is an opening for you to say, in your respondent's brief, the reviewing court has to affirm, because there is a requirement that the appellant show prejudice, and they didn't do so here. And they can't do so on reply, because you have to raise all of the arguments on appeal for the first time in your opening brief, so that the other side can properly respond to them. Also, check to see if there is a way to argue that, even if there were error, it was harmless. So that, of course, is very fact specific. So it just depends on what the error was, and in light of the whole record, was the outcome actually dependent on this, or did it have an impact on the outcome? There are limited exceptions to this rule. An appellant is not required to demonstrate prejudice if the error is what's called reversible per se. These are errors that deny a party the constitutional right to a fair hearing. Examples are denial of a right to a jury trial, denial of the right to testify or present evidence and to cross-examine witnesses, essentially constitutional issues. But for the vast majority of cases, you do need to show that the error was prejudicial. And as I alluded to earlier, there's really no set formula for determining prejudice. The legal effect, of course, of any error necessarily depends on each case's circumstances. There are some factors you can consider as you form your prejudice argument or assess its strength. If this was a jury trial, for example, consider whether the verdict was close. If the verdict was unanimous, it might be tougher to argue that had this error not happened, the jury would have gone the other way. But on the flip side, if it was a civil case and it was a 9-3 verdict, that can be helpful for arguing prejudice. Another example is consider whether the trial court cured the error. A reviewing court won't deem an error prejudicial if the trial court, sufficiently admonished the jury to disregard a certain portion of testimony, for example, or gave a curative instruction or a limiting instruction to cure this improper evidence or improper argument. That, of course, is still very fact-specific, but consider whether the court did that and whether a reviewing court perhaps might deem that sufficient. Another thing to consider is whether the admitted or excluded evidence mattered. We talked about that a little bit earlier with, what exactly was the evidence that was admitted or excluded? How much of your case depended on that? One way to assess is to look at the other side's closing argument. What did opposing counsel argue? What did they focus on? Was this evidence heavily featured in that argument? Finally, another factor you might want to consider is, did the jury ask questions? If, for instance, the jury asked one or perhaps multiple questions pertaining to the error that you claim happened, that will help bolster your prejudice argument. On the other hand, if the jury asked 0 questions and returned a verdict in less than an hour, that probably will make it harder for you to argue that the error was prejudicial. And this, of course, is not an exhaustive list. There are other non-jury trial scenarios. For instance, if there was a procedural error that there was a case in which the court erroneously didn't sign an order granting a motion for summary judgment or until well after trial was over on certain issues. That the appellate court deemed that a harmless error because all it would really do to cure the error would be vacate the judgment, go back and have the trial court sign the previous summary adjudication order, and then continue on with the process. And so it really had no substantive impact on the case. And so the bottom line really is, consider, did it matter if this error did occur, and how, to what extent did it matter, and why did it matter? These are all things that we need to be clear on as we're presenting our appeal before the court. I do see that we have some questions, so I'll pause.
Yeah, I think one of them we covered and the other one was answered in the chat.
Oh, I see. Okay.
Yeah, I think that's a great point. With any standard review questions, it's pretty specific. The Rudder Guide Civil Appeals and Writs treatise is an excellent resource to explore those specific ones. So we hope certainly that's a helpful resource for questions like that.
Yes, we refer to it as our Bible at GMSR. Definitely recommend.
Well, should I go on to number 5?
Yeah, so I'll pass it back to Kent to go over. I see that we're almost out of time, so we'll try to quickly wrap up.
Yeah, this slide will be shorter. So it's just one more question to think about. And really, this one is a little different from the others in that really before and during trial, during the litigation, is really the time to be thinking about record preservation. After the verdict has been delivered, it might be too late. It very well may be too late to make a record. So it's something to be thinking about as you're trying a case, because this quote really shows why. This is from the Court of Appeal describing what they call the 3 immutable rules of appellate practice. First, take great care to prepare a complete record. Second, if it's not in the record, it didn't happen. And third, when in doubt, refer back to rules 1 and 2. And that's a rule that we think about a lot on appeal because, Laura was talking earlier about in her experience working at the Court of Appeal with Justice Wiley that, the trial court, the jury, they see this happen. They see witnesses on the stand. They see things play out. And then on appeal, it's really on paper. It's the reporter's transcript of what happened. It's the appendix that shows all the exhibits. And so it's important to think about how is this going to look on paper? What is the record going to reflect for appeal? And generally, it's the appellant's burden to furnish a complete record. If they fail to do that, there's all sorts of perhaps the appeal could be just dismissed or kind of automatic affirmance, or if not that, at least inference is drawn against the appellant and in favor of the respondent, which might also lead to a quick affirmance. So having a complete record is really important. A few examples of deficiencies before we wrap up here that we see. An unreported sidebar. You're discussing an evidentiary objection. The judge calls the attorneys over to discuss it, so the jury can't hear. You want the court reporter there with you. And if they're not there with you right then, you want to put it on the record at your first opportunity. Maybe that happens, break for lunch, and after lunch, when the reporter's back and the jury's not yet in, ask to paraphrase the core points of that discussion on the record so that it's there. And of course, if opposing counsel would have the opportunity to object if they believe that you didn't describe the court's ruling accurately or the party's argument. And if they don't object, then that's on the record and that's clear. That's what happened. So even if you miss it right at the moment, later on in trial, there's a chance to get that on the record. And we also think about what is the evidence you're going to put into a summary judgment motion or opposition, especially in an opposition. If you lose and summary judgment's granted against your client, that's another example. What's in the record that you can point to say, this is the evidence of a triable issue of material fact. And returning to our trial examples, video deposition testimony is fairly common at trial, whether it's from a Zoom deposition or in person. A video recording can be used for a witness who's unavailable, who's not going to travel from out of state, whatever the case may be. But you need to put in the record what was the testimony that was played. And really, in my opinion, the best way to do that would be the transcript from the deposition that shows these are the excerpts that were played. You would lodge those with the trial court. If that's not done, there's nothing in the record showing what this witness testified to, then that's difficult for the appellant. The Court of Appeal could infer that it actually supported the respondent's position, that it supports the judgment. And so that could be very difficult to overcome without a full record. And then we also have nonverbal gestures. So if a witness points and you ask them, how far away were you from the intersection when the accident happened? And they say, oh, it was about here to the exit sign. And they point to the back of the courthouse. It's perfectly clear to everyone there, not going to be clear to the Court of Appeal what that means, or really the appellate attorneys like us who are reviewing the record would have no idea. That could be, I don't know, 40 feet, 60 feet, 100 feet. We don't know. Courtrooms vary in size, and we don't know where the witness is sitting. There's many other examples. They might point to this document, it's an exhibit in front of them, but on appeal, we might not know what they're talking about, or they might draw on a demonstrative. You ask them to draw, where were you when it happened, or the cars were coming from which direction, or whatever the case might be. You want to get that in the record, whether it's saying aloud, you clarify in your questions, or asking to have it moved into evidence if they drew on an exhibit. There's all sorts of things you can do to get it in the record. So those are a few examples. And just one last point that goes to record issues generally. It's kind of a one-off, but we felt that it belongs in this category because it's a prerequisite for appealing. In general, a motion for new trial is not required to appeal, but there's a very critical exception. If you want to challenge damages as excessive or inadequate on appeal, you have to file a motion for new trial. The trial judge, essentially sits as the 13th juror in trial and is can evaluate whether the damages award is just out of bounds or if it's within the range of what the jury could have awarded. And if you don't file that motion for new trial, and then you want to challenge damages as excessive or inadequate, you won't be able to challenge that on appeal. And so from the respondent's viewpoint, really, it's a pretty straightforward tip. if the appellate doesn't furnish a complete record. That's something to call out, especially anything that's important or it's just a clear gap in the record. That's really helpful to point out. And remember, whether you're the appellant or the respondent, remember that if it's not in the record, it didn't happen. That can favor the respondent, but on either side, you really want to be aware of that. So with that, that concludes our presentation. We also have appendix slides as well with more content, and we welcome other questions. I'm going to check the Q&A. I think I see a few here. Laura, do you want to take any? I'll start reading
Yeah,
them.
sure. I was going to say in response to, there's one question that asked, what is something you wish trial court lawyers thought more about that affects appeals and chances of appeal? It's exactly what Kent was just talking about. Furnish a complete record. There are several instances in which trial counsel has told me we had, this unreported conversation with the judge, and the judge said XYZ, or opposing counsel said XYZ, and we asked, is it in the record? And they said no, the court reporter had gone home for the day already. So if that occurs, definitely put it back on the record at the next day of trial, or find some other way to complete the record that way, especially if there is a crucial discussion being held. As Kent was saying, if it's not in the record, it didn't happen in the appellate world. So definitely being mindful of having everything recorded, always having either, if not in a transcript, then by a declaration. It's a lot easier to complete the record in the trial. We can't really add to it after the trial court proceedings are over.
Yeah, that's a really good question. I'll just bounce off of that and say I think I think that's absolutely right with the record. I think one or two other things I think of are jury instructions in the verdict form. I think those are really crucial too. Jury instructions are a more common source of reversible error. Laura talked earlier about how you view the evidence in the light most favorable to the appellant. So that's already helping the appellant on an instructional challenge. And, if an instruction states the law wrong, the presumption is that the jury follows the instructions unless there's evidence to the contrary. Often there won't be evidence to the contrary. So we have an erroneous instruction, trial happened, you can't really get inside the jury's head to know what they were doing, what they thought of that instruction. And so there can be a good prejudice argument there if they were told the wrong law. But oftentimes, it's very busy being a trial lawyer, and you're focused on your opening and your closing and the witness examinations and everything that goes into trial, and jury instructions get on the back burner. It's really helpful if you can think about them before trial. I think it helps shape the case too in the verdict form, goes hand in hand with the jury instructions there. And if you have a problem on the verdict form, especially if it's a special verdict form and you're the plaintiff and you fail to get the findings that you need to support your case, there's no inferences that are going to help you. If the jury fails to make the findings that you needed, that's, you could be out of luck. As far as yeah, I think those are just things that not only are they important for appeal, they can really help your strategy all throughout the case. And I'm not a trial lawyer anymore. Looking back, I would have done that more. If I could tell myself as a second, third, fourth year associate in litigation, I would have been trying to do the jury instructions and the special verdict form early in the case, so that I was really thinking about the case through the lens of the jury was going to hear. So that's a great question. Yeah, we have a couple others here. Is a denial of a motion to enforce settlement an appealable order? I don't want to answer off the cuff, Laura, unless you know. I would say that's a great one for the Rudder Guide, Civil Appeals and Writs as well, that we call the treatise. It's really helpful. It sounds like it could be. I have not dealt with that one specifically, but the treatise is really helpful for these specific examples. So that is a question to look for there. I wish I could answer it off the cuff right now, but unfortunately I don't yet have the treatise memorized. Laura, do you want to take another question?
Sure. The question about what if a pro per does not order the transcript record. This is assuming that the pro per is on the other side and you're representing a client. And if the pro per is the appellant, so once the notice of appeal is filed, the respondent also can file a notice designating record on appeal. We didn't go over that process today because that happens, after the notice of appeal is filed, not pre-appeal. But there are ways for the respondent to also designate the transcript for record. So all is not lost if the appellant doesn't order copies of those.
Yeah, and then we have a question about would a defendant's motion for directed verdict or non-suit granted after the opening statement to the jury be considered per se a denial of the constitutional right to a jury trial? So I think what we're getting at here is like, is that reversible per se? If it's erroneous, is it automatically reversible? And so that would go to our slides on standard of review and prejudice. So under standard of review, the motion for directed verdict or non-suit, if that's granted, that's going to be reviewed in the light most favorable to the appellant to see, did they really have a case? Did the trial court err by throwing it out? And I'm not sure offhand if it's reversible per se. If not, it sounds like generally a strong case for prejudice, right? The prejudice is I did not get to present my case to the jury and I had a case. It's a good argument. I don't think offhand that it's per se. The reversible per se is a fairly narrowly drawn category, but certainly if I were handling that kind of specific appeal, I would look into that to see, because if it's not per se, still there could be a good prejudice argument. But Laura, do you have anything to add on that one?
Not without looking into it further, but yeah, agreed.
We certainly welcome other questions. We know people may need to go as well. We went
Yeah.
over our time, and we hope this was very helpful for everyone. We very much appreciate all the questions. They've been thoughtful and just helpful to help us engage with you all and answer your concerns.
And our emails are listed on the last slide in case you have follow-up questions, and we're happy to chat about those offline too.
Yeah, so we'll stay for a couple minutes, and if there's no questions, we'll be complete. But feel free if you have any other questions to submit.
Yeah, thanks again.
So, in the interest of time, I say it's best that we just leave it here. Thank you both so much for this fantastic presentation, and I hope our attendees enjoy the rest of their day.
All right, thanks everyone.